Addis Business Talk with Khalid and Marid on Afro FM 105.3. We'll be talking to policymakers, investors, business leaders, and entrepreneurs to bring you the latest development taking place in the Ethiopian economic and business climate, and more importantly, what it means to you.
Good morning, good afternoon, good evening from Addis Ababa. This is Addis Business Talk with Khalid and Merid every Thursday morning on Afro FM 105.3. My name is Khalid Mawi, along with my co-host Merid Bisrat. Thank you for tuning in. The show is brought to you by Pragma Investment Advisory, an investment management and business advisory firm based in Addis Ababa, Ethiopia, along with our partners at 251 Communications, a prominent PR, marketing, and communications firm based in Addis as well. Now, we're glad to be joined today by Seyoum Yohannes. Seyoum is an attorney at Getz Law Office. He has been licensed to practice law since 2006 and draws on his vast experience to counsel clients on legal issues generated by their business. Seyoum's most recent role has been spearheading the revision of the Commercial Code of Ethiopia under the auspices of the Office of the Attorney General of Ethiopia. He was the lead expert regarding the part of the code regulating business organizations and an overall coordinator of the revision project. He also consults various international organizations, including the World Bank and the European Investment Bank. Previously, he was a national senior advisor to the Ethiopian Investment Commission and an assistant professor of law at Addis Ababa University. Seyoum earned his Bachelor of Laws from Addis Ababa University and was also awarded the University of Michigan Law School Fellowship to do his Master of Laws in Ann Arbor, which he finished in 2003. Seyoum, a warm welcome to you, and thank you for accepting to join us here on Addis Business Talk.
Thanks for having me.
Wonderful. So just to begin with an introductory question, if you can just simply tell us about your upbringing and the memorable events in your life that led you to the world of law, maybe a bit of a background about Getz Law Office, when and why you have established this firm, and what you do exactly at the company.
My upbringing is quite ordinary anyway in every respect. So you can imagine I went to effectively public schools. Then I joined Addis Ababa University and I graduated from Addis Ababa University. And I was fortunate enough to be hired by the university as a lecturer, which also opened the opportunity to go to the US for further education and most of the things you have said already. Anyway, after teaching for a while, in 2006, I got licensed to practice law privately. I was practicing law on part-time basis for a number of years. Then me and a few friends of mine actually decided to join forces so we can have more resources, so we can coordinate our effort and of course create value for our clients. So we have been now working as a group. As you know, there are no law firms in Ethiopia. We have only a law office. So essentially what we do is collaborate and help each other in terms of advising, in terms of representation, and in every respect actually. And we hope very soon the law which enables law firms to be established will be passed. There is a drafting process going on. So we hope to be registered as a law firm. That's it.
Wonderful, wonderful, Ato Seyoum. It's a pleasure to have you on the show, and I'm sure our listeners are eager to listen to talk about the revision of the Commercial Code. As you said, there are no law firm up to now, but the revised new Commercial Code will allow it, which everyone is very keen on to see it on the ground. So let's start our conversation by mentioning the main reasons that necessitated to revise this Commercial Code. As you know, to give a context for our listeners, the first Commercial Code was drafted and implemented in Ethiopia back in 1960, and it has not changed for the past 60 years. And this revision is big and it is really big for the country in terms of modernizing the country's Commercial Code. Tell us why it needed, why now, and why it is necessary to revise the Commercial Code.
As you indicated, the first code was issued in 1960, and the code was actually drafted by French experts at the time. Even the French experts, especially Professor Ascara, who was the lead drafter at the time, stated that Ethiopia should not have the most advanced laws of the days because having sophisticated laws which do not match the reality on the ground, which are not matched by institutions that can implement them, is not really good. So even at the time, the Ethiopian law of the 1960 was not the most sophisticated, the most advanced law of the time, because it had to take into account the Ethiopian reality of those days. Actually, at the time, they stated that the code would probably be good enough to accommodate change in Ethiopia for 25 years or up to 50 years maximum. But it has been already 60 years now. That means even by the expectations or in the eyes of the drafters of the 1960 code, the revision is overdue. So obviously it had to be revised. But going beyond this, the code could be tested, was put to the test actually in the last 30 years because Ethiopia began to follow market-oriented economy. And this actually exposed various things, various problems in the code. One, there are many gaps in the law, as could be manifested because of the experience in the last 30 years. There are provisions which are very difficult to apply in the Ethiopian reality. There are also multiple provisions that are very difficult to interpret or have multiple interpretations, thus making it difficult to implement the code. So these are some of the reasons. Again, in the last few decades, commerce and investment have increasingly taken, global nature. So the Ethiopians are doing business with foreign traders, foreign investors are investing in Ethiopia. That means Ethiopian laws have to be somehow aligned with the laws of other countries so that foreign traders, foreign investors can understand what to expect when they do business in Ethiopia or with Ethiopian partners. So the need to accommodate foreign traders and foreign businesses is one consideration. Another is, of course, related to this also. We are living in a very competitive world. Countries are vying for foreign investment, and we need to have a legal system which is globally competitive. This is yet another reason. And of course, going beyond this, we need to have a law which is fit not only for today, but which makes doing business easy in the coming 25 or 30 years. So the law as it stands today is not really good enough to accommodate change that we expect will be taking place in the coming, let's say, 20, 25 years. So all these reasons actually necessitated the revision of the code.
Thank you, Seyoum. I think many experts in corporate law and investment would definitely agree with you that these are important reasons and motives why an update and an upgrade of the commercial code is necessary. Now, what would you say was the revision process like in terms of the participation of stakeholders, experts, and perhaps the length of time that it took and the like?
Well, if I may start with the length of time, actually the revision of the commercial code was started during the era of the Derg. That's over 30 years ago. There were various committees established to review the code, but of course, somehow the effort lost steam, and there was also a change of government, so that didn't continue. But in 2000, around 2000, of course using Gregorian calendar, the Law and Justice Reform Research Institute was established, and that institute had actually started revision of the commercial code. That is some 20 years ago. I was lucky to be involved as a junior expert to the committee that was reviewing the commercial code at the time. Anyway, by 2001, they produced a draft, a revised draft. The institute produced a revised draft, but there was also a parallel revision process going on at the time at the Ministry of Justice. And in 2002, they also produced a different draft. Both the Justice and Legal System Research Institute and the Ministry of Justice were employing two different French experts to assist local experts. Anyway, we had two drafts by 2002. Then the whole research, revision process somehow lost steam, and nothing was done for a few years. But after a few years, then the work to integrate these two drafts and come up with an integrated draft was started. And in 2009, a complete draft which reintegrates the works of the two institutions was produced. Again, unfortunately, this code was not promulgated or was not passed, and partly because the government is really worried that the revision process might be lacking in depth, and therefore they actually launched a further effort to review, based of course on all the work done up to that point. And in 2014, a major work was done at the initiative of the Prime Minister's office. People were recruited and were exempt from all other works and given some time to revise the previous drafts, to enrich those drafts with consultative meetings and by using other experts if need be. And again, in 2017, a fourth draft was produced as a result of all this process. Of course, before the 2017 draft was developed, lots of initiatives were taking place, especially to consult stakeholders. For example, in 2014, the Addis Ababa Chamber of Commerce had hired some 14 experts, outstanding experts, to develop the position of the business community on the draft commercial code of 2009. And this outstanding group of experts, together with business people in Addis, actually came up with a 130-page report showing the position of the business community on each of the items, on each of the provisions that were included in the 2009 draft. So all this report and all these things were taken into account, and a fourth draft was produced in 2017. When this draft was about to be considered, there was also change in the country, recent change, 2018 change. And in 2018, the Prime Minister's office and the Attorney General's office wanted, again, other experts to have a look on the 2017 draft. So the National Justice and Legal Affairs Advisory Council appointed several experts to have a look on the 2017 draft, and together with those who were involved in the previous drafting process, in 2020 January, the latest draft was produced, and that latest draft was, of course, with some changes, adopted by the Council of Ministers in June. So throughout all these years, there were lots of meetings that were held with various stakeholders, including various regulatory bodies that are involved in the implementation of the code, and members of business community were intensely involved. So the code, the revised draft that we have, is a culmination of all these processes. So there was, to my understanding, lots of consultation involved.
Wow, that's quite a journey. It took almost 2 decades to revise the commercial code. I hope all the discussion was very fruitful. I mean, taking 2 decades is quite a lot of inputs. So let me ask you this: what were the guiding consideration in terms of benchmarking? I know that the 1960 Commercial Code was drafted based on the French Commercial Code, and as Ethiopia generally you follow the civil law approach, not as like the British where they use common law. If you just simply briefly clarify the difference of those two briefly, and then tell us the benchmark you used, and were you using commercial code of particular countries from outside of Europe?
Yeah, okay, thank you. Well, as a civil law tradition and the common law tradition differ basically in the role that judges and courts have in, interpretation and lawmaking process. Of course, in the common law system, judges have, they interpret laws, as do judges in the civil law system, but in common law system, the rulings of higher courts are binding on lower courts on the same issue, so long as there is no basic difference in the issues involved. They have a system of precedent, in other words, which in civil law system, generally we don't have. But I don't want to go into those details to save your time. Generally, Ethiopia, well, by and large follows the civil law system. There are some aspects of our law which are really influenced by the common law system, but again, we don't have to delve into those issues, I think. So, of course, coming to the benchmarking issue you raised, we were considering, at least in the revision process, a few things. One, generally, we were focusing on civil law countries, especially Western European countries. As you mentioned, for example, the French law may be considered the mother law. So we really looked at the 2000, the French Commercial Code revised up to 2006. We looked at the company law of Germany, which is updated up to 2010. And we were also looking at for example, the European Model Company Act of 2017. So we were focusing on generally Western European laws, one. Another was, of course, we didn't want to just look at the most advanced countries and the laws of those countries. So we were also looking at laws of countries at comparable economic and institutional development. For this purpose, we looked at, for example, West African Francophone countries. They have a certain organization called Organization for the Harmonization of Laws of those Francophone countries. And this organization has come up with a uniform act on commercial companies and economic interest groups in 2014. We looked at this, for example. We also looked at, thirdly, model laws developed by different regional and international organizations. For example, we looked at ancestral legislative guide on insolvency. Fourthly, we looked at standards used to gauge global competitiveness of legal systems. For example, you have the doing business mechanism for gauging global competitiveness of different countries, which is carried out every year by the World Bank. We looked at those things. And fifthly, we were really looking at cutting edge laws also, so that the law will remain competitive enough for the few decades ahead of us. So in doing all benchmarking, we were looking at the most recent laws. So these were the basic considerations, I would say.
Interesting. I think there's a pretty comprehensive sources of inspiration that was put into this process of revising the code. Maybe coming to a relative outlook of the code itself, how does the overall content and the structure of the revised draft code compare, of course, with the 1960 Commercial Code?
Thank you. The 1960 Commercial Code had 4 books. rather 5 books. The first one dealt with traders and businesses. Generally, the focus of this book was on sole proprietorships, but it had several rules and institutions which were also applicable to business organizations. So this book is maintained in the revised commercial code, of course, with changes, which we'll discuss in due course. The second book in the 1960 Commercial Code dealt with business organizations. We had, under the 1960 Commercial Code, 4 types of partnerships and 2 types of companies. So this book is maintained also in the revised Commercial Code. Book 3 of the 1960 Commercial Code dealt with actually insurance and carriage of goods by land and air. This book is not now contained in the revised Commercial Code. I will come to why we did this, or why the revision, the experts believed in this. Fourth book was again in the 1960 Commercial Code dealing with banking and negotiable instruments. Actually, mechanisms for settlement of payments and banking transactions between an individual bank, let's say, and clients. This book is also left out from the revised Commercial Code. I will come to why this was done. Fifth book dealt with bankruptcy under the 1960 Commercial Code. Now that book is maintained in the revised Commercial Code, but it has become book 3. Mm-hmm. Now, why is it that these things were, the 2 books were left out, and the revised Commercial Code contains only 3 books? Well, actually, the 1960 Commercial Code probably contained 5 books because of the prevailing reality in those years. Those 5 books are not necessarily logically interlinked. They don't really have to be within the same commercial code. That was the belief of experts, and this was accepted also by government. Why? Because if we look at book 1, dealing with traders and businesses, book 2, dealing with business organizations, and what has now become book 3, bankruptcy, which used to be book 5 in the 1960 Commercial Code, these are enterprise-centric laws. They deal with how a business organization is established, how it is managed, how it's run, how the relationship between the business organization and shareholders should be, the management and shareholders should be, etc. And the final book, book 3 now, book 5 in the earlier code, deals with bankruptcy. How do we save a business organization or a business which is in financial troubles from failing? And if we cannot save it, how do we liquidate it or somehow bring it to an end while making the maximum return possible for the creditors of the firm? So these are the core issues dealt with in book 1, book 2, and book 5 of the 1960 Commercial Code, which has become now book 3 of the revised Commercial Code. In other words, book 1, book 2, and the book 3 that deals with bankruptcy are dealing with the birth of a business organization, the life of a business firm anyway, and orderly winding up or bringing to an end the firm. They are dealing with these things, which are interlinked logically, which have to be dealt with in the same code. As opposed to this, book 3 and 4 of the 1960 Commercial Code are actually dealing not with an enterprise, but they deal with the relationship between a party which buys certain services from a bank and the bank, which buys certain services from an insurance company and the insurance company. They are dealing with a particular type of transaction. Of all the conceivable economic transactions, the 1960 Commercial Code chooses banking, insurance, and carriage of goods, and includes only those 3 economic transactions in the code. And how the relationship between the service provider and the client should be is governed. The contractual relationship is governed by books 3 and 4 of the 1960 Commercial Code. Now, as a result, the enterprise-centric books, book 1, book 2, and book 5, and the transaction-centered books of books 3 and 4 have no interrelationship, logical interrelationship. This is evidenced, for example, by the absence of any cross-reference between, let's say, book 1, book 2, and book 5 on the one hand, and book 3 and book 4 of the Commercial Code of the 1960. So there is no logical necessity to have them as one code. This was one reason. The second reason actually is that was more practical, of course. Banking and insurance are really interdependent with development in the rest of the world. That means, because, for example, banks have to transact with other banks outside Ethiopia. Even insurers have lots of relationship with outsiders, outside reinsurers and outside companies anyway. So it is likely that the laws governing banking and insurance will have to change more often, more quickly than those dealing with enterprise or enterprise-centric laws. That this is one reason. Another but related reason is generally, banking and insurance, especially the payment system aspect of this, is also very technology sensitive. So with advances in technology, with change in technology, we may have to change our law dealing with banking and insurance and payment system more often. So it was believed that to enable changing, or to make changing the laws dealing with banking, insurance, and payment systems easily, we should have a separate code. So that was another reason. And an effort was done to make sure that Ethiopian law is not really doing something which is not done elsewhere in the world. So the experts looked at the experience of other countries. And for example, when they looked at France, which is the country which probably has the most closely related laws with Ethiopian law, in France, they have monetary and financial services code separately. The French Commercial Code does not contain banking and insurance provisions, unlike the 1960 Commercial Code of Ethiopia. So it was believed that there was no logical necessity to have one code. It was also believed that practically it would be better if we have a separate code so we can change our laws quickly enough to adapt to changing reality in terms of financial services. And because of all these reasons, a separate financial services code is being developed. And revision work is underway for this. And of course, as I said, book 1, book 2, and book 3 contain, the revised commercial code now contains only enterprise-centric rules. That's it.
Wonderful. Thank you for that elaborative answer, Seyoum. I think that covers why it needs. It covers the content and the structure comparing the 1960s and the new revised commercial code. Moving on, what are the most significant change introduced into Book 1 of the revised commercial code?
Well, Book 1, as I said, deals with traders and businesses. It is mainly focused on sole proprietorships, but there are certain rules and institutions that apply to also business organizations. Actually, I would say the least groundbreaking changes were made into Book 1. The changes were not really very fundamental, but there were a few changes here and there. If I were to mention two main changes, I would say one is change of the Commercial Code. Article 5 of the 1960 Commercial Code actually has a list. It lists some 21 activities as commercial activities. The list is exhaustive list. It's not illustrative. And it calls a person who professionally and for gain carries out activities under the list, one of the 21 activities, in other words, a trader. And this is the approach. Of course, the 1960 Commercial Code, Article 5, does not imply or does not say that a person is not allowed to do something which is not explicitly mentioned under Article 5. But the bureaucracy in Ethiopia generally is very conservative in interpreting laws, and it had been really an impediment to progress, because people who have new ideas, people who want to respond to new demands, economic demands, by providing certain services that were not mentioned under Article 5, or providing goods not mentioned under Article 5, would face lots of difficulty embarking on their business. So what the revised commercial code does is, one, it has increased the number of economic activities which are recognized as commercial from 21 to 37. Two, it has changed the nature of the listing. While the 1960 Commercial Code was exhaustive in listing commercial activities, the revised draft code makes it only an illustrative list. That means even if an activity is not expressly mentioned under the list under Article 5 of the revised Commercial Code, so long as that activity is not prohibited by law, anybody is free to engage in the economic activity and derive whatever income that he may get from or she may get from engagement in that activity. So this is a major change. So many things not specifically mentioned, you could say, could be, for example, investment banking, could be buying only share, establishing a company to just buy shares in various companies without the company itself producing goods or services. It's possible because the list is exhaustive. No, the list is rather illustrative in the revised commercial code. And of course, the legislative process has reached a stage where the Council of Ministers has approved this, but the Parliament may add, or in this consultative process, new activities may be added if the consultative process requires that and Parliament approves any additions. This is one major change. The second change, I would say, is really aligning the code with laws that were issued after the issuance of the 1960 Commercial Code. As you may know, obviously, there were several laws that were issued in the past 2 decades, for example, that impacted on the rules in the Commercial Code. You have, for example, the Commercial Registration and Business Licensing Proclamation, which was issued in 2016. Also, there were various versions of this earlier on. You have the Financial Reporting Proclamation that was issued in 2014. We have now, I think in 2019, movable properties security proclamation. All these new laws impacted on the 1960 Commercial Code, changed bits and pieces from the 1960 Commercial Code. So the revised Commercial Code aligns the Commercial Code with the change introduced by these more recent laws. So these were the general changes, and Book 1 is generally the part of the code that was list change.
That's very interesting. I think it should be reiterated that the investment banking element that you mentioned earlier makes it, I think, today less ambiguous than ever before about companies in it themselves owning equity or shares in different companies and not necessarily having to be forced to produce their own goods or services. I think that's important for many of us to understand. Another recurring question that's asked by the private sector many times is an understanding of intricacies and changes in formats of business organizations. You've mentioned book 2 deals with business organizations. So does the revised draft introduce new types or other types of business organizations?
Yeah. No. As I mentioned earlier on, the 1960 Commercial Code had 4 types of partnerships and 2 types of companies. The revised Commercial Code actually has introduced 2 types of business organizations, new business organizations. One is a limited liability partnership. This is a type of partnership in which people who are professionally licensed, for example, they could be auditors, they could be doctors, medical doctors, they could be lawyers, could organize themselves. So this has been introduced. Of course, the limited liability partnership, which has been introduced, confers on these people limited liability insofar as they have not committed fault. And of course, also it compels the limited liability partner to buy insurance to protect clients for any fault and the resultant damage or the resultant damage that the clients may suffer. There are also various rules under which the partners may become liable, under which, of course, the partnership may be liable. Anyway, this is one form of business organization that has been newly introduced without delving into the details. The other is one-person limited liability company, private limited liability company. As you know, under the 1960 Commercial Code, to establish a business organization, a minimum of 2 members was always required. You could not establish a private limited company all alone by yourself. You need always to have another person. The effect was that people who want to establish a private limited company or a limited liability company by themselves were forced to actually invite some other persons whom they don't need to be their partners. So what they would do is, for example, they would buy shares to members of their family. It could be to a child, to your spouse, to a close family member, and they would buy him or her, for example, just one share with a par value of 10 birr. So doing this would bring you into compliance with the 1960 Commercial Code. So we would simply have straw men joining companies without having any role in the company's management, without having any interest in what goes on within the company and without the company, because of this unnecessary requirement. So what the revised Commercial Code does is, it came up with a business organization which can be formed by one person and which confers limited liability to the member. Of course, there are many detailed rules included in the revised Commercial Code to address concerns that this new type of business organization may raise, but this is one new addition to the types of business organizations contained in the Commercial Code.
Interesting. So compared to partnership companies are generally the most significant economic actors in Ethiopia. What would you say are the 2 most important changes that the revised draft code introduced in a company law?
Actually, there are really lots of changes in the part of the code dealing with companies, but since you say 2, I have to pick probably 2, I don't know. 2, let's say, change in the management organs, of company. For example, a share company under the 1960 Commercial Code is managed by the board of directors, but the 1960 Commercial Code requires that all members of the board should be themselves shareholders.
Yes.
They have to be shareholders.
Yes.
That is a really limiting the efficiency of companies because, the Ethiopian reality and business people, and it's difficult to have in the board people who are able to provide strategic leadership to the company because among the shareholders, maybe there are no people who have the right mix of training, experience, aptitude, and inclination to lead a company. They could not make people who are not shareholders but who have the required business acumen to sit on the board of companies. So what the revised commercial code does is now a share company can have on its board people who are not shareholders. Again, the 1960 commercial code did not only limit board membership to shareholders, but actually it required that even among shareholders, those who do not have sufficient number of shares in the company to guarantee, proper discharge of their duties would not sit on the board. So if you had a really minimal number of shares under the 1960 commercial code, you would not qualify to sit on the board of directors. This has been also abolished. So simply now the 1960, the revised commercial code allows board members to be non-members of the company, non-shareholders, thus increasing the efficiency of the management of that share company. Another related development is the law, the revised commercial code rather, introduces a second board also, optional board, of course. This is what the revised commercial code calls supervisory board. As you know, generally, shareholders acting together in the general meeting of shareholders are the supreme authority in the commercial code of Ethiopia. So you have three tiers of management under the 1960 commercial code. You have the general manager, sometimes called the CEO. On top of this, higher than this person, you have the board of directors. And on top of this, the general meeting of shareholders acting together. So ideally, in theory, the general meeting of shareholders is the supreme authority, but it's not really well placed to exercise its authority. One, for example, generally shareholders are too widely dispersed to be able to exert real managerial control. Second, many shareholders do not necessarily have the knowledge necessary to supervise the board and the general manager. They do not really get also all the required information on timely basis. They lack the required information. And third or fourth, or I don't know, we may say also, generally, if you have a small stake in a company, if you are owning, relatively small amount of shares, then you don't even have the incentive to dedicate time and energy to follow, scrupulously what's going on within the company. So because of all these problems, theoretically, though shareholders acting general meetings as the supreme authority, they are the least effective organ of management. So what the revised commercial code does is allows them to install a supervisory board if they want. So a share company may have a supervisory board elected by the shareholders, which is actually to act as a watchdog against the board of directors, the executive board, and the general manager. The members of the supervisory board, for example, may attend meetings of the executive board. Of course, they don't have the right to cast a vote, but they can follow what's going on. They can demand access to relevant information and generally enable the meeting of shareholders to exercise its authority more effectively. So the revised commercial code simply introduces an optional board, which it calls supervisory board. This is a major change. Another related changes for private limited companies. The 1960 Commercial Code is silent as to whether a private limited company can have a board of directors. The revised Commercial Code clearly states that a private limited company may have a board of directors. So it solves a problem in there. And also some of the rules which apply to board of directors of a share company have been incorporated into the private limited company part also, thus making governance more elaborate, more transparent, and ensuring accountability. These are, I would say, this is one major change, what I discussed up to now. The second major change actually is protection of minority investors. In Ethiopia, most people are living really from hand to mouth. People have no much money to save and invest. So you would expect a country which has really shortage of capital would have a law in place that makes it easy to contribute every little people have and do business together in one business organization. Unfortunately, the 1960 Commercial Code was almost silent on protection of minority investors. So the outcome was that if somebody joins a company with minor investment, let's say a few thousand birr or a few shares in a big company where there are thousands of shareholders, the minority would be really subjected to lots of problems, oppression, and sometimes outright embezzlement, because the law was not really prepared with a view to protecting this kind of minority investors. So the revised Commercial Code has several provisions that deal with minority investor protection. For example, we have provisions to prevent conflict of interest. Say you have a big company where there is a dominant shareholder and several minority shareholders, and this dominant shareholder could engage in various, could force the company to engage in transactions which benefit the major shareholder at the expense of the company and at the expense of the minority shareholders. So there are several rules included in the revised Commercial Code which aim at preventing this. For example, we have rules requiring disclosure of any transaction that may potentially involve conflict of interest. We have rules that require that any transaction which might involve conflict of interest be assessed by the auditor of the company, and the auditor produce his opinion or her opinion as to whether the proposed transaction is in the best interest of the company. We have also rules which prevent the major shareholder whose interest is involved in the transaction from voting when the transaction is approved. This kind of rules to prevent conflict of interest. We have these rules in the revised Commercial Code. We have also under the revised Commercial Code a few provisions which make shareholder suit easier and increase the accountability of the management. The 1960 Commercial Code did not make it easy for minority shareholders who see that their company is being embezzled or who see that their company is not being competently managed to sue the management of the company on behalf of the company. But the revised Commercial Code does several things to make suing the management easier. For example, it lowers the threshold required for derivative suit, meaning it requires the level of shareholders, the number of shareholders which are entitled to bring a legal action on behalf of the company against the management of the company. That's what it does. Again, it has rules which increase the compensation that the management which has committed fault against the company is supposed to pay. It has also provisions which enable invalidation of a transaction which involves conflict of interest, especially where specified legally required procedures were not complied with when concluding the transaction. Thirdly, the revised commercial code has provisions which grant better access to evidence and favorable rules regarding allocation of legal expenses. Under the 1960 commercial code, even when minority shareholders know that their company is being embezzled, when they know that there are lots of transactions taking place which involve conflict of interest, they could not really get the evidence necessary for them to prevail in court. There were no rules which supported getting evidence. This law, the revised commercial code, makes access to evidence easier. It also makes access to, actually makes allocation of legal expenses favorable to shareholders. Generally, the revised commercial code also allows increased participation for shareholders in certain decisions. For example, if a company is selling assets which amount to, let's say, the 51% or more of the company's assets, then shareholders have to approve the transaction, not the management or the board. And of course, to the exclusion of the shareholders who have conflict of interest. Again, under the 1960 Commercial Code, for minority investors, it was very difficult to call meetings of shareholders. Now, this revised Commercial Code lowers the threshold required for minority investors to call the meeting of shareholders. So I would say simply, to generalize, there are several rules that are aimed at improving the position of minority investors and thus allowing every Ethiopian to chip in whatever he has as a saving and do business together with other people without fear of being embezzled or oppressed by major investors within the company.
Now that's a wide-ranging and meticulous insight that you just gave us, Seyoum. I think certainly beneficial for our listeners. You mentioned earlier about technology adaptation considered as a necessity to revise the code, because I imagine the effective reality at the time was probably not pertinent to technological advancement. But my question is, are there any features in the revised code that make doing business easier, such as the use of modern technologies, for instance, the internet and so on?
Yeah, the revised commercial code actually has several provisions which aim at making doing business easier, especially by harnessing modern technology, including digital technology. For example, under the 1960 Commercial Code, there was no way in which you could hold a meeting of the board of directors of a company without meeting face-to-face. The revised Commercial Code allows the conduct of digital meeting using remote video or other means. Of course, it has several rules as to what the quality of the technology should be and what the technology should be able to support. There are rules, but anyway, remote holding of board meetings is possible. Even the general meeting of shareholders may be held remotely using technology, and there are rules regarding how this has to be held. So this is one. Another is every share company is now required to have a website. This is a must. And in the website, several information which may be useful has to be made public. For example, the memorandum of association of a company and any amendments to it must be available on the website of the company. Approved audit reports of a share company must be uploaded on the website of the company so that anybody can access it. Reports on transactions involving conflict of interest have to be made accessible on the website of the company. And any other information required by the law to be public or by the memorandum of association to be public must be uploaded on the website of the company and must be available for anybody to see. Other information which does not jeopardize the interest of the company, but is useful to shareholders, to creditors, and other stakeholders have to be made public on the website. So, while previously, for example, now if you want to do due diligence on a company on behalf of a foreign investor, you have to go to the Ministry of Trade and Industry and seek, cooperation from the relevant officers. You don't really get information about the company in which you want to invest. In reality, actually, and in reality, the people in the bureaucracy are very reluctant to give you information. So all this problem will be alleviated because of the availability of most important information about a company on the website for everyone to see. Another feature of the website is that the website should actually be able to support the holding of electronic meetings, so long, of course, if the technology permits it. So it will assist in holding of meetings of shareholders remotely. So these are some of the provisions that the revised commercial code includes as far as harnessing modern technology is concerned.
That's very good to hear, because I think this kind of change makes the business environment very transparent. So coming to the part of the code that deals with bankruptcies and insolvency, what were the biggest drawbacks of the 1960s commercial code? Let's start from that.
Yeah, the 1960 commercial code has, of course, as we said, an entire book dedicated, book 5 dedicated to bankruptcy. But unfortunately, if we look at the provisions, they are focused on the liquidation of an enterprise in trouble. Instead of preventing the failure of enterprises, actually, most of the provisions of the 1960 commercial code dealing with bankruptcy are talking about how to liquidate the enterprise and give or create as much value as possible for the creditors of the enterprise in difficulty. The revised commercial code has many provisions, many things which aim at preventing the bankruptcy itself. This is, I would say, the most important generic change.
Good. I think we're coming to our final question, and we're wondering, how did the revised draft commercial code attempt to remedy the shortcomings in the 1960 commercial code? Does it, for example, introduce any new procedures?
Well, yes, the revised commercial code introduces several new proceedings. One is what the revised commercial code calls preventive restructuring. Under the 1960 commercial code, if an enterprise is in trouble, as I said earlier on, there were not really proceedings that are aimed at healing the problem and preventing the problem from getting worse and bringing the enterprise to bankruptcy or liquidation. So we have this preventive restructuring proceeding under the revised commercial code. What this proceeding involves is, if a firm is in financial trouble and at the risk of failing, it may start this preventive restructuring proceeding, which involves negotiation with only selected major creditors of that firm. For example, this could be banks having lent it money, or major suppliers. So what this proceeding does is that the firm in trouble negotiates secretly with major creditors, banks or suppliers, let's say, and this proceeding is supervised by a court. There are timelines within which the negotiation has to be completed. So within this timeline, if all the creditors who are involved in the negotiation process come up with an arrangement that saves the enterprise and which has a prospect of them paid fully, then this negotiated settlement is approved by the court and becomes binding. So generally what this does is help an enterprise which is in financial difficulty but has a good prospect of recovering from the difficulty, avoid falling in full-fledged bankruptcy and liquidation. So this is one proceeding. Another proceeding introduced in the revised commercial code is what the revised commercial code calls reorganization proceeding. Of course, even under the 1960 commercial code, we had a proceeding which was similar, which the 1960 commercial code referred to as schemes of arrangement, but that was not really a fully developed effective mechanism. So what revised commercial code does is supplement the rules that were in the 1960 commercial code and introduce very modern mechanisms in which enable rather the reorganization proceeding to be successful and save the company or the firm from liquidation or bankruptcy if possible. And if failure is saving the enterprise completely is not possible, the revised commercial code has provisions which aim at making the possibility of the business in trouble solved as a going concern possible. So it tries to make possible selling the business or the firm in trouble as a going concern, because that way, it's likely to fetch more money for creditors if it is sold as a going concern rather than on piecemeal basis if it is done. So it has these rules. It has also, proceedings, rules rather that make the bankruptcy liquidation proceeding more efficient, easier, and time-bound, so that the creditors get, even in the event of liquidation, more value from the assets of the company which is being liquidated. It has also, what we call a discharge procedure, where, if a firm or a trader, for example, has not committed fault, but bankruptcy was the result of, let's say, unfavorable economic circumstances or extraneous things which are not attributable to the fault of a trader, then he is allowed to start afresh after a certain number of years. So we have rules for discharge of the bankrupt debtor to start life afresh, free from the debts of the past business which was bankrupt. We have also expedited bankruptcy proceedings for small businesses. The revised commercial code has a certain ceiling, enterprises which are really small and medium-sized enterprises can be allowed to go through a very simplified form of bankruptcy proceeding. So these are, I would say, generally the most important change when it comes to the book dealing with insolvency.
Wonderful. I think this is the most important revision of the part of the new revised code, which will be very helpful in the coming years to come. On that note, we'd like to thank you, Ato Seyoum Yohannes, leading attorney and main coordinator for drafting the revised Commercial Code of Ethiopia, to come on our show and to share with us the main changes done in the revised Commercial Code. And we thank you, our listeners, for being with us. I'm sure you find Mr. Seyoum's detailed elaborations very informative and very easy to digest to make your decision moving ahead. And we'd like to thank you again.